Hello everyone. My name is Wendy McLean and I'm a program lawyer with the Continuing Legal Education Society of BC. On behalf of CLE and the Law Society, co-sponsors of today's program, we would like to welcome you all to our session on the new Professional Code of Conduct for BC lawyers. Today is part one of a two-part series. Today's session will introduce the new code and focus on conflicts and confidentiality. Part two, which will be broadcast in February, will focus on a lawyer's relationship to justice, the Law Society and others, as well as the business of law. To get the full benefit of today's program, we would like to have you have in front of you two items. The first, a copy of the Code of Conduct, and the second, a copy of the reference sheet. Links to both were sent out in your sign-in instructions. After this introduction, we will be running a segment that we had previously taped. We taped it to allow us to ensure that we covered all the content properly, as well as to allow us to coordinate some meaningful answers to the questions that we hope that you will ask. So we will ask you that while the tape is running, that you type in your questions and so that we can see them and make the most of our question periods when we get to them. We may not get to every question that is asked. There are approximately 1,500 of you participating in today's program, and so we wanted to let you know that if perchance you didn't get your question asked, you have further questions, or you have a specific practice matter, that you can contact the practice advisors after today's session, and they would be happy to answer your questions for you. Now I'm pleased to introduce our two presenters for today, Gavin Hume and Lenore Roundtree. Gavin Hume QC likely needs no introduction. He practices with the firm of Harris & Company here in Vancouver, but most of you will know him as a past president of the Law Society and a life bencher. He is currently a member of the Law Society's Ethics Committee, is the Law Society's representative on the Federation Council, and most importantly for today's session, chair of the Federation of Law Society's Standing Committee on the Model Code. Also joining him is Lenore Roundtree. She has practiced in both private and public practice and is currently one of the practice advisors with the Law Society of BC. Now let's introduce all of you to the new code. Gavin, can you tell us how we came to have the new code?
Certainly. It comes from the Model Code of Professional Conduct developed by the Federation of Law Societies. The Federation consists of the 14 law societies in Canada. And in 2002, the Federation entered into the first of its mobility agreements, allowing lawyers to move across Canada with ease. And the development of the Model Code was really driven by mobility, but there are also other drivers that have influenced the development of the Model Code. That includes scrutiny by the media, and most importantly, the desire by all of the law societies in Canada to maintain self-regulation. The Federation's goal was to synchronize as much as possible the professional conduct standards across the country. So far, a version of the Model Code has been adopted by British Columbia, Alberta, Saskatchewan, and Manitoba, and the East Coast, Nova Scotia, and Labrador and Newfoundland. The other provinces and territories are actively looking at the Model Code. The one exception is the Chamber of Notaires in Quebec, which isn't actively looking at it. The result for British Columbia is a model code that's based on the Federation Model Code, but with modifications which, in the view of the Ethics Committee and the benchers, were relevant to British Columbia, necessary changes that we thought were appropriate. The process of modifying the Model Code and the BC Code of Professional Conduct will be an ongoing process in much the same way as the handbook was modified on a regular basis. In this instance, though, it will involve the Standing Committee of the Model Code, which was created in 2010. And the Standing Committee's objective is to review changes in the law, changes made by law societies, suggestions coming from law societies with a view to making recommendations for changes to the Model Code, which will then flow back down to the various law societies' codes of conduct across the country. The end result of all of this is we are no longer governed by the handbook, the Professional Conduct Handbook. That came to an end as of the end of December, and we're going forward with the BC Code of Professional Conduct, or the BC Code as we're calling it.
Thanks, Gavin. Lenore, can you tell me some of the general ways in which the new code differs from the handbook?
Sure, I'm happy to do that. First, I just want to say it's a little bit exciting for ethics geeks like me to have a new code of conduct, and it's a result of a lot of hard work by people like Gavin Hume and the ethics committee members and Jack Olson at the Law Society. It's been a number of years coming, and I think it's an improvement. The handbook was good, but this is a better and more complete code. Many of the basic principles are the same, but there are some differences, and Gavin and I will try our best to highlight for you where there are new provisions. The code, like the handbook, is a guide to the ethical duties and standards of lawyers. There are also the common law principles and rights that may come into play at any time. So it's a compendium that is beyond just the borders of the code that we have to look to. There is a table of concordance which is available on the Law Society website for the code and the former handbook, and that's a very useful thing for ethics geeks like me. I was reading just the other day that the average age of a lawyer in BC is 50, so there's a lot of people out there used to the handbook. And I'm still in the process of having to take a question, think about it in terms of the handbook, and then use the table of concordance and look it up in the code. I hope I stop that habit soon. That was the same method I used to study French in high school, and I would translate everything from French to English and back to French. It didn't work so well, so hopefully I'll be into it soon. Physically, the code and its index do look different. The code is broken into 7 chapters instead of 14, and the basic provisions are now called sections, and what we would have called subsections before are called rules. Many of the sections and rules in the code include some commentary, and the commentary is an expansion by way of example. I think the best way to think of the commentary, though, is that it is a part of the code, and the sections and rules themselves are no stronger or weaker than the commentary. The commentary includes numbered paragraphs, and when you look at the code, you'll see that some of the numbering appears to be out of sync, or there are gaps where we go from subparagraph A to C maybe. That is so that we are more in accordance with the model code, and it means that either one or the other of the two had a slight difference, but as much as possible we wanted to keep the numbering the same. The relevant annotations that some of you are familiar with from what was on the website with the handbook before are going to be migrated to the code. Hasn't happened yet. And even when it has happened, I would just ask the members who are looking at the annotations to be aware that many of those annotations relate to ethics committee decisions, or in some cases court decisions, that were made at the time when the handbook was in place. So they may not fit perfectly. The code, just like the annotations itself, are both going to be a work in progress, and things will evolve. So it's really an exciting thing to have, and I'm glad to see it here. Generally, I would just also mention that the one other difference that's quite profound when you think about it is that we now have definitions in the code that apply throughout the code itself. So if viewers could have a look at the copy of the code that they have to section 1.1, which is the definition section, you'll see several definitions there in the first rule, which is 1.1-1. These are all new. There weren't definitions like this before, and they apply every time you see any of these words in the code. So, for example, some of the defined terms that we now have is a definition for client, which includes anyone who consults the lawyer and reasonably concludes the lawyer has agreed to render services. So that's a bit of a difference. It broadens it a bit. Conflict of interest itself is now defined. We'll get to that definition later in the program because we're devoting a whole portion of this session to conflict. So we'll explain about that definition later in the program. I do want to mention about consent right now, though. The definition for consent, every time you see it in the code, it means that the client has been fully informed and voluntarily, after disclosure, has given consent. And you'll see when you look at the definition, it does always include a written component, even in oral consent situations. So that's a change. Disclosure is also defined. It means full and fair disclosure of all information in sufficient time for a person to make a decision, with the lawyer taking reasonable steps to ensure that there's been understanding. A law firm is also a defined term, and that means one or more lawyers practicing in a sole proprietorship, a partnership, legal aid clinics, in the government, in crown corporations, or in other corporations. And although it's not mentioned in the definition itself, the term law firm now extends to space-sharing situations within the context of the code. So, for example, if you were to look at paragraph 2 to the commentary of Rule 3.4-17, you'll see that there's reference in that commentary to space-sharing situations being law firms. And we'll be going to looking at the space-sharing situation itself later in the program as well. The last definition I'd just like to point out to viewers is the definition of a lawyer. A lawyer now includes an articled student within the context of the code. So students, have a look at the code.
Thanks, Lenore. Gavin, can you tell us a bit about the new provisions in the code that relate to organizations as clients?
Certainly. Rule 3.2-3 makes it very clear that when you are retained by an organization, although you may receive instructions from an officer or an employee, it is the organization that is the client. And paragraph 2 of that commentary, with respect to that rule, indicates that in the proper circumstances, joint retainers by an organization and, for example, an officer may be allowed. And we're going to say more about joint retainers during our discussion on conflicts in the second part of today's program. Now, turning to Rule 3.2-8, which it includes up-the-ladder reporting, and we talk about it as up-the-ladder reporting. When you're acting for an organization in a matter for which you know or ought to know, and heavy emphasis on the words ought to know, that the organization is or will be acting unlawfully, you must report up higher up the ladder, up to the next person in the organization or to the next group in the organization. And that could ultimately include the board of directors or the trustees in that organization. And the action must stop, or the provision provides that you must withdraw from acting in that matter, or in some cases from acting at all for that particular client. And in the case of in-house counsel, it may create a problem for them that, for example, in some situations, this could ultimately mean a loss of employment if the illegal activity does not stop.
Thanks, Gavin. I think now we'll shift our focus to the area of confidentiality. Gavin, before we focus on one of the primary fiduciary duties of a lawyer, being confidentiality, could you tell us what some of the other duties are?
Certainly. Some of the other duties include loyalty. In fact, we, as we developed the model code and the BC code, put loyalty into the definition of conflict of interest because of its importance. In addition, one has to be committed to the client's cause, and this has been described in the authorities and elsewhere as a zealous representation of the client, or to put it another way, no soft peddling because of a concern of another client. Integrity has always been a key part of the profession, and it's now in the model code and in the BC code. In British Columbia, we kept the canons, which are still part of the code. But in addition, in that same chapter, Chapter 2, there's a discussion and a statement about the lawyer's duty of integrity. Candor and honesty are set out in Rule 3.2-2, which rule includes a duty to inform a client of all information that may affect the client. In addition, one of the fiduciary obligations is to not act against a client's interests. And we'll expand upon that when we get to the conflicts portion of this presentation.
Thanks, Gavin. That was really helpful. Lenore, can you tell us where in the code we can find more information about the duty of confidentiality?
Yes, Rule 3.3-1 contains the basic statement of the duty, which is to hold in confidence all information concerning the business and affairs of a client acquired during the course of the professional relationship. I find the commentary to this rule is quite informative. Many of the lawyers who call me think they are only bound to confidence once they've been retained by a client, but really the duty of confidence begins to arise the moment that a lawyer meets with a client. And as paragraph 5 of the commentary points out, even the fact of the consultation itself is confidential. So for example, if you're being careful, and I think it is included in part of the confidentiality, you should not be publishing the lists of your clients' names without their consent. Paragraph 3 of the commentary also says that this duty applies whether the client is continuing with you or is just as a casual client. So the duty of confidentiality is quite pervasive, and I think a lot of lawyers are going to learn by reading the commentary just how pervasive that is.
It's great to have that commentary included in the new code, isn't it? All right, now let's turn to the subject of confidentiality and privilege. Gavin, is confidentiality the same as privilege?
No, they're not the same thing. Privilege is a common law concept, and it's also from time to time an evidentiary rule. There are many different types of privilege. A couple of the most commonly known are the legal advice privilege, which covers legal advice but does not, for example, extend to protect business advice. And that's obviously something that in-house counsel might keep in mind when they act for a corporation in an officer position, such as a secretary. There is also litigation privilege, which ends at the end of litigation, although legal advice privilege would generally be preserved. Privilege, however, can be lost by such things as a public disclosure or knowledge, something, again, that in-house counsel should be mindful of if they're giving legal advice at meetings where outsiders are present, such as shareholders or others. And the use of privileged document in court can cause the end of that privilege. The same cannot be said of confidentiality. As Lenore suggested, it is a much wider ethical duty and is a very pervasive ethical duty. It applies forever, subject to some exceptions in the code that we'll get to later in this presentation. And the duty of confidentiality applies to all types of information that you receive as a lawyer for a client, whether or not the information is public knowledge.
All right, I'm going to ask you both to explain some of the exceptions to confidentiality. Lenore, do you want to start us off?
Sure. Well, Rule 3.3-1 sets out some of the basic exceptions. So when you look at the rule, you'll see that first, there's always authorization by the client. Second, if a lawyer is required by law or the court to disclose confidential information, then that's permissible. And where this occurs most often is, for example, if a lawyer is subpoenaed to go to court to give testimony on a client file. Just because you've been subpoenaed doesn't mean you can start to testify and give confidential information. What you have to do is take the file with you, maintain the confidentiality, and wait until the judge rules that you're entitled to reveal. Thirdly, if you're required by the Law Society to reveal confidential information, then that's a permitted exception, and that would typically be in the case where there's an investigation or a complaint process that's ongoing. Fourth, if you're otherwise permitted by the rules, then you can disclose confidential information, and Gavin's going to expand on some of those exceptions that are otherwise permitted in just a moment. But before we leave the general provision in Rule 3.3-1, it is worth noting that the commentary infers a few more exceptions. Most notable in the commentary are the two following ones that I'd like to illuminate for you. First, there is paragraph 9 of the commentary that says, unless the client directs otherwise, a lawyer may share confidences with other lawyers and staff in the firm. This in turn leads to a duty to impress the importance of non-disclosure of client confidences on all staff members. And an outgrowth of this exception, although it's not stated in the commentary, but it's often referred to in court decisions, is an imputation which affects the topic of conflicts. So in other words, because lawyers are permitted to share confidential information within a firm, then it is imputed that one lawyer's conflict in a firm is also the conflict of the other lawyers in the firm. Now, you'll read cases, if you research it, that rebut this sometimes and give you the presumptive factors that need to rebut it. But that is the basic premise that most court decisions start from, that if one lawyer has a conflict, then everybody in the firm has a conflict. And that's because of this shared confidence exception. We also have paragraph 10 in the commentary, which addresses clients with incapacity issues. And it is inferred in that commentary that a lawyer can disclose confidential information to the extent necessary to protect a client's interest until a legal representative is appointed for that client. Also, just while I'm on the topic, I'd like to mention that there is another section in the code. It's not the one we're looking at right now, but it is devoted to clients with diminished capacity. So those that have clients in that situation should have a look at Rule 3.2-9, which lays out the basics of dealing with clients with diminished capacity. And primarily what that rule says is that a lawyer has a duty to maintain as normal a relationship as possible, but where that is not possible, the commentary to the rule lays out some suggestions for getting a representative appointed and what to do if there's a disagreement with the representative. Now I'm going to turn things over to Gavin to explain some of the other permitted exceptions.
And thanks very much. Rule 3.3-3 is described as the future harm exception, and we've always had a future harm exception in our handbook, but it's been amended or expanded. It's no longer restricted to the prevention of a future crime. The section now allows disclosure, breach of the rule of confidentiality, where there are reasonable grounds that there is an imminent risk of death or serious bodily harm. At least one case has said that serious bodily harm can include serious psychological harm. And so lawyers, when they're dealing with and this doesn't arise very often, obviously, but when they're dealing with a future harm, should turn to a practice advisor for advice on when this exception applies, because it's a difficult section to deal with, given the fundamental problem that arises when you breach your duty of confidentiality. Rule 3.3-4 allows a lawyer to disclose confidential information to defend him or herself, to defend the associates or employees in their firm, and that involves situations where there's a criminal offense or civil liability. That could obviously include a negligence claim against the firm, and it involves you breaching or permitting you to breach your confidentiality with respect to the client's affairs. And it can also occur when there's a professional misconduct allegation. Again, you can breach or you can step past the confidentiality obligation. Rule 3.3-5 allows disclosure for purposes of collecting fees. Most importantly, both of those rules make it clear that the lawyer must not disclose more information than is required to either defend or collect the fees. Rule 3.3-6 allows disclosure to another lawyer to obtain legal or ethical advice about proposed conduct that the lawyer wants to engage in. There will likely be at some point in time an additional exception added to the code relating to the lawyer's possession of property relevant to crime. This is an issue that really was highlighted as a result of the Bernardo tapes and the decision of the Ontario courts in the Regina versus Murray case. The issue is what is the lawyer to do when he or she has property that is relevant to a crime. The Benchers Bulletin in the fall of 2012 asked for input with respect to the potential language, and the Ethics Committee is in the process of considering that input and will make representations to the Federation with respect to what that language should say. This is a topic that's also on the Federation Standing Committee's agenda. So,
thank you very much. Now then, we have a few questions that we would like to answer for all of you. The first question is, how do you think the code will translate into stronger ethics in the profession within the province? Gavin?
I clearly think it's going to result in a stronger approach to ethics. First of all, the code itself has a lot of discussion of ethical issues in it, in contrast to the handbook where there wasn't much detail. We had the annotations, but we didn't have the same level of discussion or commentary. So I think that alone is going to provide considerable assistance. The second reason why I think that this will involve an increase in the emphasis on ethics really flows from work that the Federation of Law Societies done with the approval of the law societies across the country. John Hunter prepared a report on the colleges or the law schools. In that report, he recommended that law schools teach ethics. The law societies adopted that report, and in fact, by 2015, every law school in the country is going to have a mandatory course on ethics. Having spoken to many of the ethics profs from across the country, I know that they intend to teach the Model Code of Professional Conduct. And as law societies adopt the Model Code, and 6 of them have, as I've indicated earlier, and the others are actively working on it, there will be a consistent approach to ethics taught by every law school across the country, and by the time the 2018 class graduates, they'll have been educated, as I see it, with respect to the ethical obligations that are a part of practicing law, part of being a member of the profession, and it'll be a consistent approach across the country with respect to those ethical obligations. So at the end of the day, and even now, I think there will be a greater emphasis in the profession on ethics.
Thanks, Gavin. Another question asks, 3.2-2 is troubling me. I sometimes can't divulge information to a client, like the other party's address, where there's a restraining order or parts of a sealed psychiatric or ministry file. Lenore, how would you respond to that concern?
I think if the law overrides the ethical duties, then you have to comply with what the law says. So in the case of a restraining order, if a piece of information can't be divulged, then I'd say that 3.2-2 takes a back seat to whatever the law has said.
All right, thanks, Lenore. Another question said, this person had a question about the definition of client. The language, quote, render legal services on his or her behalf, unquote, in subsection B, strikes me as odd. Is the intention that a client is a person to whom the lawyer renders legal services? For example, if I am retained by a trade union to provide advice and assistance to a member on a matter that is not a grievance, for example, human rights claim or a WC matter, should I consider the union as well as the member a client? After all, I am providing legal services on the union's behalf. Also, why does the definition of client refer to a natural person, and I quote, his or her behalf, unquote, but not legal persons, which might be more accurately reflected in its behalf?
Do you want me to answer that question?
Sure, Gavin, it's all yours.
So dealing with the definition of, or the use of the word person in the definition of client, person does include a corporation. So the concept, the issue is really how broadly do you define person? The answer is it does include a corporation, and perhaps we could add the words its as well as his and her in that definition. But it's clearly intended to include a corporate entity, either a society or an incorporated company or an entity such as a trade union. Going to the first point, which is being retained by a union to represent a member of the union in a human rights complaint, as I understand the question, the term retain refers to the union paying on behalf of the member of the union for the services rendered. Assuming the union is not involved in actively giving instructions at the same time as the member is giving instructions, then I think the client is clearly the individual, the member company on whose behalf the lawyer is acting. And in fact, the code under the provisions dealing with the payment of fees specifically contemplates that a third party might be paying for the fees of the particular client. The only obligation that arises under those circumstances is that the client, the union member in that instance, clearly understands where the fee is coming from. But if the instructions and all of the decisions are being taken by the member as opposed to the union, then I think the client is restricted to that member who is the subject matter of a human rights complaint.
I have a few more questions that have come in. One asks, in preparing a resume or CV, may a lawyer include the names and citations of cases in which the lawyer acted for a party without first obtaining the party or client's express consent? Lenore, did you have thoughts on that?
I do. I think if it's a public case, you could include that in your resume. That's a document that anyone could read and could see the names of the counsel and the names of the participants in the litigation. It's a different matter, though, if you're putting together a resume and you want to have a list of your clients. You should be getting consent from all those clients before you put such a list in your resume.
I have a couple of more questions that have just come in. One asks, what suggestions for dealing with turning away a potential client on the basis that after performing a conflict search, their spouse's name turned up, needing to respond without revealing that you had been consulted by the other spouse? Gavin and Lenore, did you guys have any thoughts on that?
Go ahead, Lenore.
Oh, I think you just say, I'm sorry, I can't act. If it's a private matter that you don't have consent to reveal the name of the wife, if I'm understanding the question correctly, you couldn't reveal why.
Yeah, I think.
And I would agree with that. You don't have to reveal why you can't act. You simply need to say, we have a conflict. Sorry, I can't tell you why, but I have a conflict, and say goodbye to that individual.
Right, I think that's what the question was answered. If it wasn't, please type in a clarification for us. I have another question that asks, how did the changes affect in-house counsel? Are there any particular issues that are specific to them, you think, within the code?
I think that there are provisions that do impact on in-house counsel. The one that comes to mind, which we will be talking about in the later part of this program, is up-the-ladder reporting. There will be issues that potentially might arise if the corporation for in-house counsel, where in-house counsel is employed, is in fact engaging in criminal or unlawful activity. There's a whole process of that's set out in that particular provision that requires in-house counsel and counsel for that client to report up the ladder and try to bring that to a stop. At some point in time, if the illegal activity doesn't end, in-house counsel may be in a position where they'll have to resign. The whole topic of in-house counsel, however, is one that I think is going to require more work in the future. It's certainly been on the agenda for the Ethics Committee in British Columbia. We just, because of the advent of the model code and the need to bring that into British Columbia, we haven't yet gotten to that topic, but it's been on the Ethics Committee agenda for the last several years to look at some of the specific issues that impact on in-house counsel. The up-the-ladder reporting is the only one I can think of off the top of my head.
I think I might just add that the duties of confidentiality are the same for in-house counsel as for private counsel, but the roles of in-house counsel can shift sometimes. Sometimes they're sitting as corporate secretary, sometimes they're sitting as a lawyer. And they've got to be careful, I think, when they're in a role as a corporate secretary, and especially if there's outside advisors in the room, that can undermine privilege pretty easily. I know that's a different concept from confidentiality, but I believe that some in-house counsel, especially the younger ones, sometimes forget their different roles and forget who they're speaking with and whether or not things are as protected as they might like them to be. But I agree with Gavin. The Ethics Committee is going to, I hope this year, tackle some of the in-house counsel issues, because there are some troubling things for in-house counsel, not just within the code, but just generally in practice. I don't think that they always have the same resources as some of the other groups.
Thank you to you both. That was a great response to a question. I have another question that says, is there a problem with offering a free phone consultation with the new definition of client under the code? Lenore?
I don't think it's any different than it ever was. It's not a new concept. The consultation itself is what forms or begins to form the lawyer-client relationship. The duty of confidentiality arises at that point. It always has. Whether it's free or not is irrelevant, really. Even if you subsequently decide not to act for somebody and are never paid, you still have begun to form a lawyer-client relationship. You still have the duty of confidentiality. And I believe it's Rule 3, I wrote it down, actually, I'm cheating here, 3.3-1, Commentary 4, Paragraph 4, says that there's no need for a formal relationship. So it's a bit of a red herring for somebody to think, well, I gave free advice, so I don't have any duties now. Or not a red herring, it's a wrong way to think about it.
And you, in addition to the issue of confidentiality, you may find yourself in a position where a conflict, in fact, exists. You have information which you can't use because of confidentiality, and you then have a conflict and can't act for another party against that individual. So that's really to say that one has to be very careful about those informal consultations, those telephone calls. You have to think carefully about A, the conflicts issues at the beginning of those calls, and B, what potential difficulties you're getting yourself into going forward if somebody else comes along and wants you to act on their behalf against the individual that you're just having the casual conversation with. So one of the matters commented on in the model code is the need to be careful with respect to those informal consultations, just because of the reason, or for the reasons that Honora has identified. And the courts over the years have also recognized that even in those casual situations, a solicitor and client relationship is developed, and they have knocked firms out of the box because of that informal communication giving rise to a conflict.
Thank you for that clarification. I know it's a problem that arises for all of us, even at the classic cocktail party when somebody says, oh, my cousins ran into a problem.
That's exactly right.
That's very helpful, thank you. Another question asks, does the code address obligations of lawyers to respect the confidentiality of other lawyers? For example, when a confidential document mistakenly comes into the possession of the opposing lawyer. Gavin, did you have comments on that one?
Certainly. Rule 7.2-10 deals with this. There's nothing new with respect to this. It's just expressed in greater detail in that particular rule. So the obligations when you receive inadvertently, or however you get it, something that's clearly not intended for your use but is intended for the use of the other side, is spelled out. Your obligations are spelled out in that rule. And I know that this is an issue that sometimes becomes quite complex, and so I would suggest if it's not clear as to what you should do as a result of reading that rule, you should turn to a practice advisor to assist in talking the issue through. And from time to time, these issues, in fact, have come to the Ethics Committee, and you will find, once the annotations are moved over to the BC Code of Professional Conduct, several examples of opinions, or several opinions that the Ethics Committee has given on how to handle those situations. So That rule, 7.2-10, along with the annotation, may also provide advice to you with respect to how to handle those situations where you come into possession of information that clearly wasn't intended to you, was instead intended for the other side's counsel.
I might just expand on that a bit too, to say that sometimes documents come into your possession, or it can be e-information as well, that maybe wasn't intended for the other side but does belong to the other side. The classic situation is when one spouse has hacked into the computer of the other one. Those not only have all the ethical obligations around them, but there's also sometimes a criminal aspect. Was that a crime to hack into the computer? Does your client need to get a bit of advice before they give you any more, criminal advice, before they give you any more instructions on what to do with those documents? So they can be very complex situations. And I believe within the last year or so, my timeline might be a bit off here, but I believe it was within the last year, the Benchers Bulletin had an article on these kinds of issues too. So take a look back into the past maybe 6 or so archive issues.
All right, that was helpful. I think everybody's gotten an email by mistake somewhere along the road, as all of the autofill works on all the computers now. A final question. Can you comment on the confidentiality duties of a lawyer with regard to former clients who are adverse in interest with current clients? Gavin.
Yes, Rule 3.4-10 and -11 deal with those circumstances. And with respect to confidentiality, the confidentiality of a former client has to be maintained. In addition, those rules spell out when you cannot act against that former client. For example, that you can't attack the legal work that you've done before on behalf of that former client. So those two rules deal with that issue. They also provide when you can act against a former client, not the individual lawyer who may have confidential information, but another member of the firm with the appropriate screens set up. That may or may not work well given the size of the firm, but there is a provision for and a language to discuss how you act against a former client with the use of screens with different lawyers in the same firm doing the work.
All right, let's switch now to focus on the issue of conflicts, a huge issue. Gavin, where should we start talking about this?
Well, we've already talked and discussed several of the fiduciary duties, among them the duties of confidentiality and loyalty, both of which are central to the conflicts rule. If you look at Rule 1.1-1 of the Code, which is the definition section, there's a definition of conflicts of interest, which means the existence of a substantial risk, and I'm quoting, of a substantial risk that a lawyer's loyalty to or the representation of a client would be materially and adversely affected by the lawyer's own interests or the lawyer's duties to another client, to a former client, or to a third person. Rule 3.4-1 contains the basic prohibition and says simply, a lawyer must not act where there is a conflict of interest except as permitted under the Code. But when you apply the definition of conflicts of interest to this rule, it includes all conflicts between the interests of one client with the lawyer's own interests, another client, or a former client, or a third person. Before we discuss this rule further, it's worth noting that some key cases in the area, some of which are referenced in the commentary to the rule. If you look at the commentary, paragraph 6 of the commentary says that the rule reflects the principles articulated by the Supreme Court of Canada in the Neal and Struther decisions regarding conflicting interests involving current clients, that a lawyer must not represent one client whose legal interests, heavy emphasis on the word legal interests are directly adverse to the immediate legal interests of another client without consent. And this duty arises even if the matters are unrelated. Now, these last words reflect the so-called bright line test that was first articulated by Mr. Justice Binney in Neal and reaffirmed by him in Struther. And it's caused some difficulty in interpretation. There's a recent case that is not mentioned in the commentary, and that's the CNR versus McKercher law firm case, which is scheduled to be heard by the Supreme Court of Canada on January the 24th of this year. The CBA and the Federation of Law Societies have both received intervenor status and will be before the court to give the court another chance to interpret the bright line test, which has been variously interpreted since Neal and Struther. In one instance, it's interpreted as an absolute prohibition, absent consent, to act adversely against a client, even in unrelated matters. And on the other hand, as a lesser prohibition that allows lawyers to act if they are able to demonstrate there is no substantial risk that the representation of one current client will be materially and adversely affected by the representation of another client in a new and unrelated matter. In effect, what I'm really saying is stay tuned, because there will be possible further amendments flowing from the Supreme Court of Canada's decision and further interpretation of this conflicts rule. Now, if we turn back to the rule itself, some of the factors to be considered in determining whether there is a conflict are set out in paragraph 7 of the commentary, and they include the following matters: the immediacy of the legal interest, whether the legal interests are directly adverse, whether the issue is substantive or procedural, the temporal nature between the matters, the significance of the issue to the immediate and long-term interests of the clients, and the client's reasonable expectations in retaining the lawyer for the matter.
Lenore, there's further commentary to 3.4-1. Could you boil it down for us even further?
Yes, the commentary provides a number of examples of situations where conflicts may arise. Some of them are more obvious than others, but they include in paragraph 8A, it gives the example of acting as an advocate in one matter against a person, and when the lawyer is trying to represent that same person on another matter, that may be a conflict. Paragraph 8C gives the example of acting for a business client on a commercial matter and at the same time giving legal advice to an employee of the business on an employment matter. That may be a conflict. Paragraph 8D gives the example of acting in a situation where the lawyer has a personal financial interest in the affairs of the client, and yet the lawyer's been asked to act for this client. That shouldn't be hard to say. We're going to look more particularly soon on the rules on lawyer-client conflicts, but I just would like to say that if you are in a business relationship with a client and you do act for them, not only might you be in a conflict, but you might also find that if there's some allegations of negligence down the road, that you've fallen outside the lawyer's insurance fund policy because of the business and benefit exclusion. Anyone who's interested to learn more about that should check the Law Society website under the insurance link, and you can find information on that business and benefits exclusion. Paragraph 8E of the commentary talks about a sexual or a close personal relationship with a client may be a conflict. It should be noted that this sort of conflict can be cured if someone else in the firm acts. In other words, this is one exception to that imputation I was talking about earlier, where the conflict of one lawyer is not imputed to others, unless of course they're all having close personal relations with that client. Paragraph 8F gives the example of acting as a director and as a lawyer for a corporate client. That may be a conflict because of the obscuring of the legal and the business and the practical advice aspects. It gets very complicated sometimes if you're trying to do too many things for a client. And I should also note that that kind of relationship may also jeopardize lawyer-client privilege, which, as Gavin has already pointed out, is easily undermined. Paragraph 8G of the commentary reminds lawyers who practice together in a cost or space sharing arrangement that they also have to be aware of the potential for conflicts. And we will be going over some of the specifics of the rules for space sharing relationships a bit later in the program. Before leaving this topic, it should be noted that paragraph 0.1, here's an example of some of the out-of-sync numbering, not even out-of-sync, just odd numbering. Paragraph 0.1 of the commentary to Rule 3.4-0 and Appendix C to this code maintain the ability for a lawyer to act for more than one party in a real estate transaction in the proper circumstances. And essentially these circumstances are familiar to many of you. These are the simple conveyance situations, and not too much has changed in that regard if you have a look at Appendix C.
Gavin, are there any situations in which a conflict of interest can be waived by a client?
Yes, there certainly are, and they're to be found starting in Rule 3.4-2. That section says there can be both an express or an implied consent by the clients to a conflict. And this is an important qualification. If the lawyer reasonably believes there will be no material adverse effect on the representation of or the duty of loyalty to any of the clients. So that's a very important qualification. Paragraph 1 of the commentary makes it clear that the disclosure is a part of the express consent, and if it is not possible to provide the client with adequate disclosure because of the confidentiality of information of another client, then the lawyer must decline to act. Remember that the fact that you represent a client is confidential matter, and so in many cases, unless the clients actually know that each is a client of yours or agree to that disclosure, it may not be possible to get the consent. Paragraph 2 of the commentary makes it clear that disclosure of relevant circumstances and the reasonable foreseeable ways the conflict could potentially affect the client is essential to obtaining the client consent. This includes disclosure of the lawyer's relations to the parties and any interest in or connection to the matter. When you take the definition of consent into account, express consent also requires at least a written communication recording that consent. Implied consent only arises in limited and certain circumstances set out in the rule and where all of the following conditions apply. First of all, it's got to involve a client which is a substantial entity, governments, financial institutions, or entities with in-house counsel. And this is an issue that's also going to be potentially addressed in the Supreme Court of Canada decision in CN and McKercher. Part of the appeal challenge is this point of the so-called professional litigant exception. The second requirement is that the matters must be unrelated. And thirdly, and obviously very importantly, there can be no confidential information that affects the other matter. And fourthly, the client has commonly consented in the past to lawyers acting for and against it in unrelated matters. So you have to have all of those four conditions in place before you can act on the implied consent.
All right. Lenore, is it possible to get consent in advance from a client?
Yes, it is in some circumstances, Wendy, but it's not always going to be effective. And in particular, viewers should have a look at paragraphs 4 and 5 of the commentary to Rule 3-4.2. That commentary lays out a few parameters around advance consent. First of all, the material risks must be explained to the client of giving this advance consent, and the more detail that's given to the client, the more likely the advance consent will be effective. Secondly, open-ended advance consent will ordinarily not be effective because of the likelihood that the material risks of a particular transaction will not have been, or could not have been in some cases, been explained. Although if the client is sophisticated or was independently represented at the time of the open-ended consent, it is more likely to be effective. And although it's not a prerequisite to advance consent, independent legal advice is advisable. And advance consent must be recorded in writing, and that can be done in the retainer letter.
So are there any limits to the waiver of a conflict?
Yes, Rule 3.4-3 expressly states some of the limits. And it says that despite all of what we've just discussed with respect to consents or waivers of conflicts, a lawyer must not represent an opposing party in an actual dispute. In other words, a client can waive a potential material impairment, but not an actual one. So even if a waiver has been given on a potential impairment, once an actual conflict arises, the lawyer cannot continue to act in the conflict unless it's resolved, nor can the lawyer seek a waiver at that point. It's too late to go in asking for a waiver to the conflict once it's actual.
Gavin, the code contains some new provisions with respect to concurrent representation and joint retainers. Can you explain the difference between these two concepts and lay out some of the parameters around each of them?
Certainly. Concurrent representation is in fact new. It wasn't contained in our handbook, and it is dealt with in Rule 3.4-4 and arises when lawyers in the same firm act for concurrent clients with what is described as competing interests. For example, clients who are pursuing the same business opportunity but are in a situation where there's no actual dispute as between those clients. Joint representation was in the handbook and is also in the new BC Code, and it's dealt with in Rule 3.5-5 to Rule 3.4-9. It occurs when one or more lawyers act for two or more clients in the same matter or transaction. And I'll get back to this in a moment, but I want to go back to the concurrent representation, which, as I said, is new. This wasn't in the BC handbook and is now in the BC Code. Concurrent representation involves competing interests. That is not defined by the code or the jurisprudence, although in paragraph 2 of the commentary to the Rule 3.4-4, there is an example provided, being a number of sophisticated clients competing for a corporate acquisition whose interests may diverge, but who are not in an actual dispute with respect to that acquisition. The requirements for allowing concurrent representation are set out in the rule itself and are as follows. Disclosure of the risks involved when a lawyer acts in a concurrent representation situation. Independent legal advice must have been received, including advice with respect to the risks involved. The clients are to decide if it is in their interest, so it's the decision of the clients. Separate representation for each client by a different lawyer in the firm is required, and the lawyer or the groups of lawyers and their staff must be screened off using the appropriate screening mechanisms, and there's reference to the screening mechanisms that we're all familiar with respect to transferring lawyers, and they're referenced in that particular rule. And all the lawyers must withdraw from the clients if there is a dispute. I should add that in my view, these rules will be difficult to follow in many small firm situations, or in situations where one of the concurrent clients has been represented by the firm for any significant period of time before the second client comes along, and during which there has been no screening. Now, turning to joint retainers, the steps that are to be taken are set out in the rules 3.4-5 to 3.4-9, and those that were also in the handbook. It includes the disclosure that the lawyer has been asked to act for both clients. Remember, disclosure, as was discussed earlier, is a defined term and includes a complete disclosure in a very timely way. Second, you must advise the client that no information received from one client will be kept in confidence from the other client, and that's even if the clients consent. The information must be shared. Disclosure that if a conflict develops and is not resolved, the lawyer will be required to withdraw from that joint retainer. In some cases, an independent legal advice should be recommended, and in the case of a continuing relationship with one client, as that is set out in Rule 3.4-6, being one in which the lawyer has a continuing relationship with one client for whom the lawyer has regularly acted, the lawyer must recommend to the other joint client that that client obtain independent legal advice before the joint retainer is in fact put in place. Rule 3.4-7 requires the client to consent and stipulates that the consent must be in writing. The Law Society expects to have precedents on its website soon that will conform with these rules. If a contest develops between the clients, Rule 3.4-8 and 3.4-9 apply, and generally no advice can be given on the contentious issue, the area where there's a disagreement with the joint clients, and the lawyer must refer the matter to other lawyers. You can also advise on settlement options by direct client negotiation if no legal advice is needed and the clients are sophisticated clients. So some advice can be given under limited circumstances. If the issue is not resolved, then, as I said earlier, the lawyer must withdraw from the joint representation. There is a provision that will permit a lawyer to act for both clients at the client's consent if they're not under disability, to try and resolve the dispute, but that is a separate, operates separately. Rule 3.4-9 allows the lawyer to continue to advise one of the clients if the clients have agreed in the initial retainer letter that if a contentious issue arises, the lawyer may continue to advise just one of them while the other client must be referred out. But you must spell that out at the commencement of the relationship, and I think it needs to be done in the retainer letter.
Lenore, is there anything you can add?
About the conflicts? Sure, Wendy. Before we leave the conflicts area, I think there are a couple of other provisions that should be highlighted. For example, paragraph 2 to the commentary under Rule 3.4-5 has some specific information about how lawyers who receive instructions from spouses or partners on will preparation are to set up their client relations. These are joint will instructions, is the common parlance used by some lawyers. Essential to the understanding of what this relationship is all about is that the clients are to be treated as joint retainer clients. Gavin has just explained what joint retainer clients are. And if the lawyer does advise on the wills and subsequently receives further instructions from only one of these clients, this is not part of the joint retainer. It is a new retainer matter, and the lawyer may have a duty to decline to act in this new retainer matter as set out in the commentary. For example, the commentary says, likely you're going to have to refrain from acting in the new retainer matter unless one of the parties has died or there's been a permanent dissolution of their marriage, situations like that. Another of the provisions that I think should be highlighted is in Rule 3.4-17 through to 3.4-26. These are the rules that relate to conflicts that arise as a result of lawyers transferring between firms. The concept is not new, and many lawyers have probably looked at the handbook provisions on conflicts and lawyers transferring between firms. And they're very similar in this new code. But the principles still involve screening and the like, and they're more or less the same principles about screening as previously in place. But there is some clarification as to who these rules apply to, and it is expanded from what was commonly thought before under the handbook. For example, they now expand to space sharing situations, to transfers to and from government services, transfers into and out of in-house counsel positions. And I should add that these rules are under active consideration by the Federation Standing Committee on the Model Code. And if there are changes, the Law Society's Ethics Committee will have the opportunity to clarify any ambiguity or changes that might arise as they relate to BC. I'd also like to mention that Rule 3.4-11, and I'm sorry, I know this seems to be out of sync, but you'll see when I get into this definition why I've done it in this order. It's a new rule, and it recognizes that in an unusual circumstances where a lawyer has acted for a former client, another lawyer in the firm may act against the former client in a new matter if the firm establishes it is reasonable that the firm act in the new matter under the circumstances. And as part of the test of reasonableness, the rules refer back to 3.4-20, which are the conflict rules between transfers of firms. And It's one of the rules I just mentioned in relation to lawyer transfers, and these considerations for acting include the adequacy and timing of measures taken to ensure there will be no disclosure to the former client's confidences to the lawyer having carriage of the new matter. I've got to restate that, sorry. The considerations for allowing a lawyer to act under Rule 3.4-11 include the adequacy and timing of measures taken to ensure there will be no disclosure of the former client's confidences to the lawyer having carriage of the new matter. In other words, there's adequate and timely screening mechanisms that have been put in place. They also include the extent of any prejudice to a party and consideration of the good faith between the parties. In other words, if there's a lot of bad faith between the parties, you're not going to be able to act under this new rule.
Thanks, Lenore. Earlier mention was made that there is now a defined conflict of interest term and how it includes conflicts that apply to the lawyer's own interests as well. Gavin, can you tell us more about that?
Certainly. Rule 3.4-26.1 to 3.4-41 relate to lawyers' conflicts with clients. There are a number of topics covered in these rules, and they include doing business with the client, investments by and with clients, taking mortgages from clients, borrowing from clients, loans to clients, guarantees by lawyers, taking gifts from clients, including testamentary gifts, and acting as a surety for a client. To be more specific, Rule 3.4-26.1 sets out the basic principle that has been in place for many years, which is a lawyer may not perform, and I'm quoting, a lawyer may not perform any legal service if it would reasonably be expected that the lawyer's professional judgment would be affected by the lawyer's or anyone else's relationship with the client or interest in the client or the subject matter of the legal services. Although the basic concepts are the same, there are several new provisions in the code that relate to the rules respecting potential lawyer and client conflicts. Several of the rules in this section are new or have been expanded. The detail is too much for us to get in today. Suffice it for me to say that there are expanded requirements under these rules for recommending or requiring independent legal advice when a lawyer and a lawyer's clients conflict. For example, Rule 3.4-30 requires a lawyer to recommend independent legal advice when a client is granting a mortgage or transferring any property, including shares as security or payment of a fee. Rule 3.4-34 goes further and requires a client to obtain independent legal advice before a lawyer can lend money to a client. Rule 3.4-27 and 3.4-27.1 and 3.4-32 set out the requirements for how to give this type of independent advice. As well, and in addition, Rules 3.4-37 to 3.4-39 and their commentary have put in place new provisions restricting the ability of a lawyer to accept gifts, including prohibition on requiring the executor to retain the lawyer for the administration of the estate on making oneself a beneficiary under a will.
Lenore, are there any special rules around conflicts that relate to lawyers and space sharing arrangements?
Yes, there are. The concept and the rules or the provisions or principles are more or less the same, but what's different now is there's more commentary around the space sharing situations. So Rules 3.4-42 and 3.4-43 deal with space sharing relationships. And Rule 3.4-42 says these rules apply to, and I'm quoting here, to lawyers sharing office space with one or more other lawyers. So the test is whether physical office space is shared. Many callers that I have seem to be confused and think these space sharing rules will only apply if they have some sort of financial or fee sharing agreements in place with other lawyers, and they'll say, well, I have no agreement, we're just sharing space. Well, the basic test really is you're sharing space, so these rules apply. You may also, on top of that, have a financial or fee sharing arrangement, but it's just the sharing the physical space that kicks the rules into place. So if lawyers are sharing space, then Rule 3.4-43 applies, and it requires that unless lawyers in such situations agree they will not act for clients adverse in interest, then they must disclose in writing to all of their clients that a space sharing situation exists. They must disclose the identity of the lawyers who make up the firm, and that the lawyers in the firm are free to act for other clients who are adverse in interest. Paragraph 1 of the commentary to the rule makes it clear that lawyers who do not want to put all of this in writing then must search conflicts of the clients of the other lawyers in the firm. But in that case, paragraph 2 of the commentary reminds people that the lawyer must have the consent of each client for the purpose of the conflict search. This goes back to the duties around confidentiality, about how even the names of clients are confidential without a client's consent. Before I leave the rule itself, I'd just like to mention we do have a lot of calls. I think more and more lawyers are coupling up and sharing space. And there is an article on the Law Society website that lawyers who are contemplating doing this should have a look at. It's an article on the website called Lawyers Sharing Space. And many of the tips apply equally to lawyers sharing with non-lawyers too. There are lawyers who are starting to share with some other non-lawyers. And in some cases, the tips that are in the article, I think, are even more important when you're sharing with non-lawyers, because non-lawyers are not familiar with concepts such as confidentiality. So the tips include such things as taking care with sharing receptionists, keeping separate fax machines, keeping computer and storage facilities locked away from those who don't have access, making sure that confidential client space is available for interviews. And as well, lawyers who are only space sharing and are not wanting to be part of a deemed partnership need to be clear in their signage and communication with the outside world that they are not partners. So for example, words should show up in the retainer letter that might say that this is a group of independent practitioners not practicing in a partnership. Business cards and websites have to be careful to make sure that that same message is given out to the world or potential clients that are dealing with the lawyer's website. And anyone who's interested in this might have a look at some of the case law, and I'll just mention one of them now that does disclose some of the tests that would lead to a determination of apparent partnership. And that's the decision of Kent and Oliver, and the site for it is 2000 BCSC 1154.
Thanks, Lenore. Gavin, at the beginning of the discussion, mention was made of the definition of conflict of interest and how it includes conflicts affected by a lawyer's duty to a third person. How would this arise?
Now, the language from this definition, the conflict of interest definition, including the reference to a third person, comes from Mr. Justice Binney's decision in the Neal case that we talked about earlier. There's no real explanation of what is meant by a third person or when a lawyer could owe a duty to a third person. So I've thought of a few examples. A lawyer who sits on a board of a corporation will owe duties to the corporation as a director of the corporation. That's one example. A lawyer who has entered into a mediation agreement may owe a duty to the mediator or others under the agreement. A lawyer who acts as a trustee or an executor owes duties in accordance with those positions. And another example is a lawyer who enters into a confidentiality agreement may owe duties to third parties under the agreement. Those are the sorts of situations that you might want to refer to a practice advisor at the Law Society if you have concerns about your obligations with respect to that part of the definition of conflicts of interest.
Thank you for all your questions. We have quite a few of them, and so we will try to answer as many as possible within our time frame. The first question says, regarding Section 3.2-5, when acting for a regulatory authority, is it inappropriate to advise the person that further continued behavior or failure to remedy a particular situation may result in being charged with a regulatory offense? Lenore.
Well, that's a good question. You can't threaten for the purpose of gaining a benefit for the client. That's the purpose of the rule. So if that's why you're going forward with this information about a charge under the regulatory authority, it's wrong. But it seems in the purview of that question, the issue at hand, it seems to involve a potential charge under the regulatory authority's purview, and I'll use the same word, I guess.
Responsibility.
Responsibility, that's a better one, thank you. So I think it would be fair and reasonable to inform the person in that case. It's not being done for the ancillary and wrong purpose of threatening for some other advantage. It's being done within the scope of that actual retainer.
Okay, thank you. The next question is, on the issue of conflicts with former clients, is there any special consideration for lawyers who have acted for an extended period of time for government on specific interests and then want to move into private practice? Would the lawyer be prohibited from representing private clients against the government forever thereafter? Examples: Aboriginal litigation, motor vehicle PI claims, civil forfeiture, tax matters, corrections, PI cases, etc. Are government civil litigators the most restricted lawyers in their future practice options if they leave the government? Gavin, I think you had a few comments on this.
Yes, I think the answer to the question is no. We're not precluded from acting forever against the government. There may be restrictions. Obviously, if the particular matter that you're seeking to act on is something that you have confidential information on, or with respect to that, from your role when you were acting for government, then clearly you couldn't act. So that is, I think, very obvious. The other circumstance where you may be precluded from acting is that you know so much about the internal workings of government. You have such a deep understanding of their particular policies, which are confidential, not public, then you may well put yourself in a position where you can't act. There's one case authority that I can recall of, though of course I can't remember the name, where the lawyer who had moved from public practice moved from acting for the Crown into private practice was precluded from continuing to act because that particular lawyer had a lot of information about the client that she was in effect acting against. It was a special part of the police force engaged in some particular focused work, and she, as a result of the work she'd done previously, had a lot of confidential information. So she was precluded and disqualified from acting for an accused because of that unique knowledge. So I can see circumstances where your past experience, your knowledge, the confidential information that you have as a result of working for the Crown would preclude you from acting. But I think as a general proposition, the answer to the question is no, you're not going to be prevented forever from acting against the Crown or government.
Thank you very much. I'm sure that's a huge sigh of relief for all lawyers currently working within the government right now. Another question is, many lawyers are married to lawyers in other firms. Obviously, both understand the need to maintain confidence, but does the relationship give rise to a conflict of interest that clients must be informed of?
I think, again, the answer is there is no conflict of interest. In fact, this, as I recall, has been addressed by Chief Justice Finch in a BC Court of Appeal decision, where the specific issue was whether or not the lawyer on the other side should be disqualified. And his answer, I think, was to this effect, that he assumed that the members of the profession are going to act ethically, they would keep the information they have as confidential, and that as a result, the lawyer, the wife or the husband, was not going to be disqualified from acting. So I think the answer to the question is no.
All right. Another question asks, has a new model letter to jointly represented clients been prepared? Lenore.
A new model letter is being prepared. It's currently with the Ethics Committee, and my hope is that before the end of next month there'll be something up on the Law Society website. Currently we still have the old letter up there with a warning that says it's not in compliance with all of the provisions of the new code. And certainly anybody who's struggling with the actual language in a letter should phone a practice advisor, and somebody can help them out with some of the changes that might be needed.
Thank you for that. We will all be waiting for that new letter to be posted on your website. We received a number of questions about space sharing, and instead of going through each individual question, I think we're going to ask just Lenore to clarify some of the issues and items that she's seeing in these questions so that we can answer more of the questions all together. So Lenore, can you comment please on space sharing?
Yes, it's not a new concept. I know just by the number of questions that we've had that maybe because of the new code, for the first time people are actually paying attention to the rules about it. But very little has changed in the rules. And I think that many of the questions that we got were either forgetting to ask or didn't think to ask or didn't know to ask. The sort of entry-level question, which is, are these space-sharing firms that you're asking about set up to allow lawyers to take clients who are adverse in interest? Because if they're not set up that way, then the answer to most of the questions would be no. It's like any other firm. You have a conflict. It's imputed to all the other lawyers. So my suggestion for those of you who are in space-sharing situations is go back, read the rules, the commentary, read the article that's on the Law Society website, and think about your situation. And if you haven't already set it up such that you can be taking clients adverse in interest, you're going to have to speak to your other space sharers and see whether the consensus is that that's the way you'd like to do business. And you'll have to change the way that you've been communicating with each other and what you're telling your clients if that's the case. One of the questions I noticed particularly addressed the issue of sharing staff and receptionists. And really, strictly speaking, you shouldn't be doing that. These are firms that are sort of working within the umbrella of the space, but they're actually separate little groups of people. Then, if you're not set up to take adverse interest in particular, you shouldn't be sharing a receptionist.
Thank you for that. I know that space sharing is a very thorny issue that many people struggle with. And
I think so.
I'm sure that all of us really appreciate the clarification. We had a very specific question come in that said, what about the situation where a lawyer what about the situation where there is a lawyer with a spouse who is a judge? The lawyer does not appear before the judge who is their spouse, but other members of her firm do. I am also certain that the lawyer has nothing to do with the matters brought before her husband, the judge. She is a solicitor who does not do court work. However, her spouse is a provincial court judge in a small town who hears many family files that I appear on. Do I have a duty to point out to my clients that the judge is married to a lawyer of the opposing firm? Is there even a conflict? Meaning, should all lawyers from that firm be prevented from appearing in front of that judge?
Well, I think the answer to the second question is no. Those other members of that firm should not be precluded from appearing in front of that judge. And to some extent, you can analogize to the BC Court of Appeal case that I commented on earlier, and Chief Justice Finch's comments with respect to the assumption that lawyers are going to practice ethically. Obviously, this judge and this lawyer are maintaining the appropriate separation from each other going forward, and I think that's an appropriate assumption. Whether you have a duty to advise under those circumstances, I don't really think you do, because I think you can make the assumption that the judge and the members of the other firm where his wife is working are going to continue to act ethically. So I don't think you have a duty to advise. You might want to make that observation so nobody's taken by surprise, but I don't think a duty exists there to advise your client that the lawyer on the other side has as a partner or a member of the firm a lawyer who is a spouse of the judge that you're going to appear in front of.
Thanks, Gavin. I had a question that says, if a client proposes to secure legal fees owed to his or her lawyer by granting a mortgage over real property, does his or her lawyer have to insist on separate legal representation for the client with respect to the mortgage the mortgage transaction? Lenore?
I'm just reading Rule 3.4-34. If a lawyer lends money to a client before agreeing to make the loan, is that what we're talking about here?
No, I think they're trying to secure legal fees, and the person is trying to say that they would give them a mortgage to secure those legal fees.
My recollection of the rule, without having it right in front of me, is that there's an obligation to suggest that independent legal advice be obtained. But I don't think it's mandatory, but I may be corrected shortly by Lenore, who's desperately looking for the rule.
I'm desperately looking. I have to say, at a minimum, you have to at least suggest independent legal advice. It's possible you actually have to ensure that it happens, and I'm not going to find it in the time we have, so let's just leave it at that.
You know, fair enough. I don't expect you guys to have memorized the code, at least not yet. There was another question that came in that said, in terms of space sharing, what about the virtual office packages? Are there any special considerations that you would need to think about under the space sharing rule with virtual rather than physical office sharing arrangements? Lenore or Gavin, did you have thoughts on that?
My reaction to the question is the same rules are going to apply. You have to continue to worry about confidential information, access to the computer technology. If you're in the virtual world and you haven't set it up in a way that would preclude lawyer number one from accessing lawyer number two's client list and the information about that client, the virtual world isn't going to make any difference to the basic principles of having to maintain the confidentiality and the assumption that when you're in the same firm you're going to be sharing information, confidential information with respect to each other, unless you've set up ahead of time the appropriate ethical walls.
Thank you. Another question is, if a lawyer is on the board of directors of a society or a corporation, does that result in the same duties that would arise as if they were counsel, especially in regard to conflicts? Lenore and Gavin, I think you both have content for that one.
I don't think so. I think you're in a different role when you're on a board of directors. You're, in some cases, a business advisor. You might have some technical expertise unrelated to the law. You might be a spiritual advisor, a cultural advisor. There's all kinds of different reasons why people sit on boards. Not to say that you can never be in a conflict. But just sitting on a board per se does not import all the duties of counsel, nor does it necessarily import all the conflict provisions. Where I do think it can cause a problem is if you think that your own judgment or thoughts on the matter are becoming clouded or obscured, then you've got to think about whether there's a conflict. If your duty to that board as a third person, even though it's not a client of yours, if your duty to that board starts to conflict with your duty to a client, then you definitely have a conflict. So it is a different role, but it doesn't always lead to a conflict.
And I would agree with that. The definition of conflicts does speak in terms of third parties. That would be a third-party relationship which could give rise to a conflict, doesn't necessarily give rise to a conflict. It's really a function of keeping the activities that you're engaged in as a director separate and apart from the activities you might engage in providing a legal service to that particular board. If you merge the two, then you have to worry more about whether you're getting into a conflict. So acting as a director and the firm acting as solicitor for the firm doesn't necessarily give rise to a conflict. It just is possible to give rise to a conflict.
Great, thank you for that. Another question is, a lawyer is asked to incorporate a new company. At the time, the lawyer is retained by the individuals who come to him. After incorporation, the lawyer continues to act for the company. It is easy to see how an actual or potential conflict can arise. Which rules and what issues govern this situation? Lenore.
I would say that this is a joint retainer situation like any other. Often when you have a new incorporation that's being formed, the incorporators will become the first shareholders and the first directors. And they're all going in the same direction, and there are no conflicts. You set it up because you do have multiple clients in that case, like a joint retainer. And then if things do fall apart and a conflict arises, you unwind it, just like any other joint retainer that hits a conflict. And you have to have a look at the rules and see how you can get out of it. But basically, nothing can be held in confidence. And if the parties are starting to fight, you need to then ultimately refer everybody out if you can't get it resolved.
I think this is going to be our last question. If an incorporated company has holding companies for its shareholders, is it a conflict to be the corporate solicitor for the parent company and one or more of the holding companies?
I think the simple answer to that question is no, it's not. They're obviously all working towards the same objective, and acting for both the parent and the wholly owned subsidiaries doesn't create a conflict per se. The circumstance for a conflict could arise is where the subsidiary is only partially owned. Then one has to think carefully about what conflicts might arise as between one of the two parent companies to the subsidiary. But if it's a wholly owned subsidiary, unless there's some unique circumstances, I think there's no conflict, and you can act for both the parent and the wholly owned subsidiaries under most circumstances.
Well, I'd like to thank everybody for joining us for today's session. I'd like to thank Lenore and Gavin for their participation and all of their hard work on this project. We do hope that you will join us for part 2, which will have new information on the Code of Conduct, which will be broadcast in February. And we hope that if you have any further questions or your questions that did not get answered today, you will contact your practice advisor with the Law Society. Thank you everyone for joining us today. Today's session counts for 1.5 hours of your CPD credit and also that amount of time for your ethics proportion of that credit. Thank you again for joining us, and we hope to see you again at CLETV.